New powers activated. Canada can cancel your permit without warning. Welcome back to Canada Chronicles. Across Canada, temporary workers, students, and visitors are waking up to a new reality, one where even an approved permit might not be as secure as it once seemed. Ottawa has quietly activated sweeping new powers that allow immigration officers to cancel, suspend, or alter your status without warning. For thousands of people building their lives here, the rules of the game have changed, and few saw it coming. In this video, we'll uncover how these new powers under Bill C-12 are reshaping Canada's immigration system, why they matter for anyone holding a work, study, or visitor permit, and what real steps you can take to protect yourself before it's too late. And stay tuned until the end, because we'll dive into something even more concerning: automated status checks in the next frontier. Could an algorithm cancel your permit before you know it? It's a development every immigrant and applicant needs to understand before the next wave of enforcement begins. Make sure to subscribe to Canada Chronicles and turn on notifications so you never miss critical updates that could impact your future in Canada. Let's get started. The signs of a system under stress. It began with mounting backlogs and growing uncertainty. Hundreds of thousands of temporary permit holders were stuck in limbo as the system struggled to keep pace. For many, the issue wasn't just waiting for approval, it was the risk of that approval being taken away. What was once a right to stay while waiting for a decision is shifting toward conditional permission that can be revoked. The system that once said, "You may stay," now warns, "We may pull your permit at any time." The Government of Canada has admitted that its immigration and border laws are outdated, designed for a slower era. In response, it introduced Bill C-12, the Strengthening Canada's Immigration System and Borders Act, on October 8, 2025. This bill is a turning point. For the first time, it gives immigration and border agencies the authority to cancel, suspend, or amend temporary resident permits, study permits, work permits, visitor records, and even pending applications in the name of public interest, integrity, and security. For anyone currently inside Canada on a valid permit, the assumption of stability has changed. What was granted can now be revised, suspended, or terminated without warning. Thousands could find themselves suddenly out of status, facing deportation or forced departure, even if they followed every rule. How the new powers work. Bill C-12 allows the federal government to act in three powerful ways. First, cancellation or suspension of existing documents. Officials can now cancel or change immigration documents, including study permits, work permits, and visitor records, if they believe doing so serves the public interest or maintains system integrity. Second, refusal or interruption of pending applications. The law lets the government pause or close programs entirely, wiping out applications that have already been submitted. Third, expanded national security and data sharing authority. Immigration, Refugees and Citizenship Canada, and the Canada Border Services Agency now have broader powers to share information across federal and provincial systems and to act swiftly if any pattern of risk is detected. In simple terms, a permit can be canceled not only for breaking the rules, but also if your category, employer, or school is flagged for compliance concerns. Even if you did nothing wrong, you could lose your status if the institution linked to your application becomes non-compliant or the category is deemed too large or risky. One major example is the Startup Visa program. Thousands of applicants depend on designated business incubators for eligibility. If those incubators fail compliance reviews, the government can cancel every linked application. Why this shift matters? This matters because the foundation of immigration stability has changed. What was once approved until renewal is now approved, but subject to cancellation. There are three major consequences. Loss of status without warning. The new law allows cancellation without an individualized hearing. You might only learn of it when re-entering Canada, applying for an extension, or submitting a permanent residence application. Program-specific vulnerability. Those in high-volume or scrutinized streams face the greatest risk. If an entire category, like an international student cohort or an employer-driven work program, is frozen, compliant applicants can be affected too. Reduced certainty in long-term plans. Many temporary residents view their stay as a stepping stone to permanent residence. Under this framework, that path can collapse overnight if a permit is revoked before a PR application is filed. Although Bill C-12 is still being studied in Parliament, Government agencies are already adjusting procedures as though it were in effect. That means its impact is being felt even before it officially becomes law. What could trigger cancellation? Several scenarios could activate these new powers. Non-compliance by sponsoring institutions or employers. If the school or company tied to your permit violates federal rules, your permit can be revoked alongside theirs. Backlog or capacity management. To clear excessive wait times, the government can mass cancel pending applications in certain streams. Integrity concerns. Irregularities in a program or participant group can lead to broad cancellations. Public interest or security issues. The term public interest now covers economic, political, and social reasons, far beyond traditional security grounds. Interrupted transition to permanent residence. If your temporary permit is canceled, your PR pathway may collapse with it. These cancellations might come with little or no notice. Critics warn that the new law undermines procedural fairness and allows categorical decisions without individualized review. The human cost. Behind these legal changes are real people, students, families, and workers whose futures depend on stability. Imagine a student enrolled at a college that suddenly loses recognition. Their study permit, though valid, could be suspended along with every other student's. Consider a foreign worker whose employer is investigated for misusing the temporary foreign worker program. Even if that employee followed every rule, their permit could be voided because of the employer's misconduct. Industries such as healthcare, construction, agriculture, hospitality, and transportation rely heavily on temporary foreign workers and new permanent residents. Sudden cancellations would not only disrupt lives but also damage the broader economy, leaving employers short-staffed and projects delayed. For families awaiting permanent residence, this shift is even more devastating. Permit loss can separate spouses, halt applications, and undo years of progress toward a new life in Canada. What you can do before it's too late. While the system may feel unpredictable, you still have control over how you prepare. Stay fully compliant. Always meet the conditions of your permit. Keep up with your studies, follow work restrictions, and renew early. Keep every receipt, letter, and document proving your compliance. Monitor your sponsor or institution. If your employer, college, or designated organization faces investigation or loses status, seek advice immediately. Plan ahead for permanent residence. Don't assume your current permit guarantees future eligibility. Strengthen your case early by maintaining clean records and checking new program requirements regularly. Consult a licensed immigration lawyer or consultant. With the law shifting so rapidly, professional guidance is vital, especially if your status is linked to high-risk programs, such as the Startup Visa program or employer-driven streams. Stay adaptable. Immigration policy is fluid. Have a backup plan, explore alternative provinces or programs, and never rely on a single pathway. Thanks for staying with us this far. We appreciate your time and hope you're finding this information valuable. Automated status checks in the next frontier. Could an algorithm cancel your permit before you know it? While Bill C-12 expands human authority to cancel permits, the next phase could come from technology. Canada's immigration system is rapidly adopting automation, cross-system data sharing, and predictive analytics to flag potential risks. Experts warn that as the database network grows, future decisions may rely on algorithms that identify discrepancies automatically. For example, if a student's enrollment credits drop below the average or an employer's payroll report shows fewer hours worked, the system could flag the case for cancellation before a human officer ever reviews it. Bill C-12 strengthens information sharing among federal, provincial, and territorial partners, setting the stage for this digital transformation. The move toward automated alerts and integrated databases could eventually make status reviews near instant. While there is no public confirmation of automated cancellations yet, the infrastructure to enable them is clearly being built. That's why vigilance is crucial. Check your employer or institution's compliance record. Confirm that you're meeting all conditions of your permit, from study load to work hours. Keep your contact information and employment data up to date, and always keep documentation of any status changes. The system is moving toward data-driven enforcement, and being prepared could mean the difference between maintaining your legal status and losing it without notice. A system in transition, and you need to act. This is a defining moment for Canada's immigration system. The authority to cancel permits without warning is no longer theoretical, and automation is bringing that power closer to real-time enforcement. Your permit may still be valid today, but it's under constant review. The government's tools are expanding, and the standard for compliance is rising. Staying informed, organized, and proactive is no longer optional. It's essential. The positive side is that knowledge gives you power. By documenting everything, following the rules closely, and anticipating change, you can protect your future in Canada. As we've seen, Canada's immigration landscape is changing fast. The activation of Bill C-12's new powers marks a turning point, one where even those who have done everything right could face sudden reviews or cancellations. But awareness is your strongest defense. Staying informed and keeping your records accurate will help you weather any policy shift. And remember, the system isn't just evolving, it's becoming smarter and more automated. The move toward data-driven enforcement means your future status could one day be decided by an algorithm rather than a person. That's why it's more important than ever to stay alert, compliant, and proactive. If you found this breakdown helpful, don't forget to like this video, subscribe to Canada Chronicles, and turn on notifications so you never miss vital updates about immigration, policy changes, and life in Canada. Thanks for watching. See you in the next video.